Thank you, Mr. Chair. Minister, in relation to the $262 million buyback of part of the exploration licence 7223, now just to be clear, what exactly are you buying back for that price? It's not land, is it? You're not buying any land.
Well, the government has agreed to buy back 51.4% of Shenhua Watermark's mining exploration licence. It's the part of the licence being relinquished that covers the flat, fertile agricultural area on the Liverpool Plains, commonly referred to as the black soil plains.
Okay, but that licence actually expired in February 2016, didn't it?
The licence, I believe that's the, is that the actual date? I'll let the Deputy Secretary give you the exact date.
So,
just
yes.
send the mic to you, please.
Sorry. Yes, the expiration licence was due to expire in February. However, the company submitted a legal and appropriate application for renewal prior to its expiration date, and that therefore it remains on HOP.
Okay. So can you tell us the date you received the application? You're going to take it on notice. But just to be clear, you're spending $262 million to buy back half, or 51.4%, of a licence that has in fact expired. That's what you're doing. Just to be clear? Is that correct?
Well, I think the Deputy Secretary directly responded to that point.
And I can clarify the dates if he wishes.
I'm advised that the Deputy Secretary can clarify the dates and address that part of your question.
Ms Hargreaves, you can leave the mic facing you because the Minister's got his own.
Okay.
Thank you.
So yes, EL 7223 was due to expire on the 22nd of February in 2016, and a renewal application for the full 100% retention of the area was lodged on the 5th of February 2016.
Okay. But again, just to be clear, you're spending over $250 million to buy back just over half of something that has expired.
Well,
Just to
you're not even
clarify,
getting any land for this
nothing
price.
is expired if a legitimate renewal has been submitted to the government. In fact, that licence remains on foot until a determination on that renewal is made.
I'll come back to that. But they've had the benefit
that's
of that.
clear, isn't it?
Pretty clear.
Good.
But just to be clear, the company's had the benefit of that exploration licence now for the better part of a decade, hasn't it? It's had it for over 8 years.
Yes, indeed it has.
And
since it was approved under Minister MacDonald back in 2008.
And indeed renewed by Minister Harcher, your close friend, in 2012. Correct?
Yes, there was a renewal.
Yes, by that minister.
Well, there was a renewal, yes.
You don't like Chris Archer's name being mentioned? A bit embarrassed, are we? In relation to the other half, you say there's an application for the whole. Does that mean you're still deliberating on what to do with the other 48.6% of the exploration licence?
Shenhua has not yet been issued a mining licence, of course, only an exploration licence.
Sure, but they haven't applied for a mining licence yet, have they?
No, they haven't.
But
They have not applied for a mining licence yet, that's correct.
But in terms of the exploration lease, they applied for a renewal of the whole lease. Your government...
Excuse me just a minute, I just wanted to take... Yes, okay. Sorry about that. Could you just repeat your question?
They've applied to renew the whole of the EL, and the government has decided, at least in relation to 51.4%, not to renew that, to buy it back. But in relation to the other 48.6%, is it the case that you haven't yet made a final decision about whether or not to renew that part of the EL?
That's correct. It's still being assessed.
Okay. And if someone was to say that there has been an agreement reached with the New South Wales government to partially extend the lease, would that be true or false?
I don't understand the question.
Okay.
Perhaps you could rephrase that, because that's not
Is there an
a
agreement?
concept under the...
Okay, is there an agreement with the state government of New South Wales to agree to an extension of the other 48.6% of the EL?
No.
Are you aware that Shenhua, the company you're dealing with, has made a statement to the Hong Kong Stock Exchange on the 12th of July, which says, and I quote, on 29 June 2017, Watermark Proprietary Limited reached an agreement with the New South Wales Government in relation to partial extension of the exploration licence. Are you aware of that statement being made by Shenhua?
No, I'm not aware of that statement being made.
Is that statement false?
The statement is not correct, as the exploration licence hasn't yet been renewed.
Again, so the statement is false.
Well,
It's not factually correct.
I think it's just the
The Minister did say the statement was not correct, so I don't know that he can be more clear than that, Mr. Searle.
it's...
Was it from the water was it on?
No, I was just assisting.
I'm not I cannot... in terms of the language used by Shenhua, that's a matter for them, but I've given you a statement as to what the actual position is.
Okay. Now, the $262 million, how did your government calculate
Yes.
that, and which budget line item does it come out of?
So the I've got it. Yeah. The that one. Oh, yeah. What page is that on? In 2008, under the previous Labor government, Shenhua purchased the exploration licence for $300 million. The government is refunding 51.4% of that amount, plus an adjustment for the holding of the capital over the last 9 years, and that the total figure, that's how the total figure of $262 million is reached.
Okay, so it's you characterise it like the Karuna buyback as a refund. Is that correct?
Mm-hmm.
Not compensation. Is that correct?
Correct.
Again, could I just read to you from Shenhua's statement to the Hong Kong Stock Exchange on the 12th of July, where it says that the pursuant to the established policies of protection of agricultural activities on the black soil plains, the New South Wales Government withdrew the exploration licence of approximately 100 square kilometres within the Watermark exploration area and provided Watermark with economic compensation amounting to just under $262 million and accepted the application for the partial extension of the exploration licence. So that statement's also not true, is it?
Mr. Searle, whatever statement that Shenhua made to the stock exchange, what you should understand is that that statement was not shown to us or approved by us before it was made.
Oh, and I'm not suggesting it was, I'm just exploring whether or not, what the truth of the matters are. You've got a major company with whom your government is doing business saying one thing, and your government in this state saying something completely different. You say it's a refund, they say it's compensation. They say they've got a deal with you about extending the EL, you say it's still being assessed. I'm just interested in knowing who's telling the truth.
Yes, but the exploration licence remains on foot until the assessment
That wasn't
concludes.
the question.
No, well, I was just
I'm
making
not
sure that you were quite clear.
I'm quite clear on that, but they say they have a deal with you and you say they don't. So are you telling the truth or are they telling the truth?
Point of order, Mr. Chairman. The Minister's answered this question.
Point of order. Look, as we know, the Minister can answer the question as he sees fit.
Well, we entered a negotiation with Shenhua, and as a result, they gave up 51.4% of the exploration licence that they have. And that was the area that involves the prime agricultural land on the flat, fertile plains, often commonly referred to as the black soil.
Okay. But we'll just come to the renewal. Now, under the Mining Act, the decision maker, that is you, are not bound to renew an authority over the area nominated by the applicant. That's correct, isn't it?
Yes, that's correct.
And you may renew a smaller amount of the land as long as it's not different land to the one originally covered.
Yes, that's correct.
So you have a discretion,
Yes.
and there's nothing in the Mining Act that says if you choose to renew a smaller part of an EL, that the government is bound to make any compensatory payments or refunds, does it?
It's not an unqualified discretion or so there are a limited number of circumstances in which I can refuse it, but
Sure.
So it's not unqualified.
But as long as you adhere to the restrictions on the discretion, as long as you don't break the law, Minister, there's nothing in the Mining Act that requires the government to refund any part of the original purchase price of the EL, is there?
That's quite correct.
Okay, and if your government has decided to refund part of the 300 million,
For a very good reason.
well, except they've had the benefit of the EL for 8 years, you're only buying back half, and you're giving them almost every penny they paid for it. It's like you're just
No.
financing the next stage of the mine.
No, that's not correct.
Well,
they're
how
being
is it?
given back an amount that reflects their original purchase price, discounted for the fact that that we are purchasing only 51.4% of it back, and with an adjustment that reflects the fact that we've held the capital over the last 9 years.
But they've purchased a product or a licence. They've had the benefit of it for 8 years. There's not many products or things you can buy and then hand some of back and get such a handsome refund. On what basis, on what legal basis are you doing this?
Well, I'm happy to go to that, but I should make it quite clear that the company has spent at least $160 million on exploration.
Okay, well, just
So it's not simply a case of giving them back money
Well,
for no
except Minister,
effort expended on their part.
Minister, when companies buy exploration licences, that's a licence to look to see if there's a resource to explore, correct?
Sorry, I missed that. Could
When a
you just
company
repeat that?
purchases an EL, it's for a limited period of time,
Yes.
and it's a licence to look. It's not a licence to mine or anything else. is it?
Correct.
And it doesn't come with a rolled gold guarantee that they will make money or that they won't lose money on the transaction.
Yep.
That's correct?
That's correct too, Mr. Searle.
So everything you've said just makes it seem like you're intent on doing special deals for mining companies to make sure they don't lose any money or that they lose as little as possible. I mean, they paid their money, they've had the benefit, they've taken their chances, and now you want to refund them because they're only getting potentially half a renewal.
Mr. Searle, you're not mentioning one relevant fact, which is that there has been a development approval process undertaken for this mine, and it has reached a stage now, although it's not complete and that there are other matters to be dealt with, that this mine may well go ahead. And by buying back 51.4% of the exploration licence, what we've ensured is that there could be no future mining on the fertile black soils of the Liverpool Plains. By buying back the area of the exploration licence that encroached onto the plains, we've ensured that Shenhua or any other company in the future won't be able to apply for an expansion of the mine or new development consent for a mine on the land.
Okay, again, just pausing there. No one has a right, unqualified, for an expansion of a mine, do they?
Well, no, there
So
would
you're not taking
obviously
off them.
have to be
Sure.
development consent
But
for
the point
that.
is, you're not taking off them something they currently enjoyed. They didn't have a right to mine. They still don't have a right to mine. And so, therefore, this idea they should be compensated because they might, at some future point, not be able to expand a mine that today
Sorry,
doesn't exist.
just a second.
It's
I
ridiculous.
apologise, Mr. Searle, but my Deputy Secretary was giving me some advice, and I will have to ask you in a second to repeat the latter part of your question. Sorry.
Saved by the bell.
No, I'll allow you to ask the question again, given that the Minister requested it.
But the actual approval of a development consent for even that part of the exploration licence that they retain gives them certain rights, and you can't just overlook that.
We'll come back to that. Just returning to the Chenois watermark matter, your press release with the Honourable Niall Blair makes a big song and dance about how you're protecting the black soil, but in fact, when you look at the site or proposed site of the 3 mine pits, and you look at the overburden dumps, and then you also look at the floodplain areas, and also the land that I think planning has mapped as being biological and strategic agricultural land, if you lay them all over each other, you can actually see that the mine will still impact on those areas, particularly the B-Searle lands. That's correct, isn't it? So it doesn't. Your measure doesn't protect all of the black soil.
He doesn't know what B-Searle is.
Yeah. My advice is that it won't.
At all. It doesn't touch
That
on the
is the
floodplain areas
advice.
at all?
So I haven't a copy of that map.
I'm happy to provide the map.
It might assist both myself
Well, Mr.
and
Hargreaves,
the Deputy
like a copy of
Secretary
that map?
if you
Yeah.
supply a
Stop
copy
the
of
clock.
that map.
No, we don't. Oh, I'm happy to table that.
Secretary, can
I'm
we
happy
just take
to-
it around to
I
the
wonder.
That's right.
Well, I wonder if Ben, if you'd like a response,
I'm
can
happy.
you provide a copy to
Yeah, no,
us?
I'm happy to provide a copy. One's from planning, and the other one, I think, was a submission to the pack from Mr. Duddy. I'm happy to take it on notice. Mr. Buckingham
All right.
indicated
Sorry,
that...
can I just be clear on that? So, in terms of that question, you're happy for us to
Yes.
respond to you on notice?
I am, yes, very happy.
Do
Mr.
that.
Buckingham pointed out that under a clause, a special condition of the EL, if there was no substantial commencement of a mine in the 8 years, subject to reasonable excuses, of course, the Government of New South Wales has the unrestricted ability to cancel this project. Now, given that between obtaining final state regulatory approval in January, February last year and last October, they'd made no effort to commence a mine at all, didn't even make an application for a mining licence. Why didn't you do what you did with Karuna and simply bring the whole matter to a close?
I took. Yeah, I got that. I took advice from the department on that point, and let me make this clear. The condition only allows cancellation of the licence if there are no reasonable excuses for not substantially commencing the mine development within 8 years of the granting of the original exploration licence, or that the failure was related to circumstances beyond its control. The company made reasonable efforts to comply with this provision, but was prevented due to numerous legal and other regulatory interventions which were outside its control.
But which were entirely
Chenois
expected
has
when they
been
signed up to the
subject
deal.
to unprecedented government review at both state and Commonwealth levels and a number of legal challenges. This prevented the usual development process being completed within the anticipated timeframe.
Minister, they're still 8 months overdue with their water and biodiversity management plans required by the Commonwealth Scientific Expert Committee. There are regulatory non-compliances. They haven't even made an application for a mining lease, even as we stand here. If you really wanted to protect the land out there, you would have just brought the whole matter to a conclusion.
Well, I think you've asked that question previously and I've answered it.
Okay. Will you provide the legal advice so that we can all see the basis on which the government has acted?
Mr. Searle, you were in legal practice
Yes.
before you came to this place.
Yes.
I think at one stage you worked for an Attorney General
Correct.
in the State Cabinet. You'd be well aware that legal advice is privileged, and I'm unable
Yeah, it
to
is
do
privileged, but the privilege rests with the government. If you wanted to instill greater public confidence in this decision of yours, you could release the advice if you chose. What are you hiding?
that. We're not going to be releasing the
Oh, I
advice.
expected that would be your answer. In relation to...
Just as in the same circumstances, governments will have made the same decision responsibly and in the interests of the state.
Under Section 380 capital A of the Mining Act, the fit and proper person test, that's a very important power the Minister has. Can you tell the committee where your agency is up to with its long-running investigation into whether Wollongong Coal is fit and proper to hold a mining licence, given it's been nearly 2 years since complaints were handed to your agency?
Yes, I'm going to invite the Chief Compliance Officer of the Resource Regulator, Lee Shearer, who's handling that matter, to give you an advice.
Excellent. I don't think she was available last year, so welcome.
Welcome. So we commenced our formal investigation in July last year into really to determine whether Wollongong Coal was fit and proper under the Act. There's essentially 2 legs to this inquiry that we've conducted. The first leg is around their financial capacity, and that's been a concern for some time.
In fact, you've taken legal action against them 3
certainly
times in the last year.
And that demonstrates that whilst we've got the fit and proper person inquiry investigation underway, we're not taking our foot off the pedal in respect to other actions that we can take. So we commenced a prosecution recently for failure to pay, which is hinging around the financial capacity, and those matters are before the court, so I won't progress that any further. The other leg that's important for us to consider, because the fit and proper person really at its heart is about probity issues. So a matter was referred to us last year about the primary shareholder, which is Jindal Steel and Power, and the director, Mr Jindal in India, and his referral, along with a number of other people, for corruption in India. So that matter's still outstanding. The only matter that we can't progress that until those issues have actually been resolved.
Well, actually, that's not quite true. When you look at 380A, it makes the point that the Minister can exercise his discretion whether or not there are criminal convictions in other jurisdictions.
Well, our investigation has to rely upon matters that I'd suggest need to be underpinned by lawfully and legally obtained evidence.
Mm-hmm.
We don't have that.
Mm-hmm.
We have essentially a newspaper clipping that refers the matters about the corruption issues in India. It has not been progressed any further.
Mm-hmm.
So until that matter's resolved, that particular limb of the fit and proper inquiry cannot be progressed.
Okay, well, let's just fast forward to what's happening here in New South Wales. In the last year, Wollongong Coal, through systematic withholding of monies from its subcontractor Delta SPD, tipped that company into administration. The creditors' report of 10 August makes it quite clear that hundreds of jobs in the Illawarra have been put at risk and in fact have been lost because of that action of Wollongong Coal, disputing bills, delaying the payment of agreed bills and the like. Can you tell us whether that's part of your consideration as to whether or not that company is fit and proper to hold a mining licence?
All of the matters around their financial capacity are being taken into account.
It wasn't their capacity, it was their willful withholding of money from their subcontractors, tipping them into administration and costing jobs.
That sounds like exactly what she was talking about. But anyway, I'm sorry. I should
Well, that might be a problem
going.
if Wollongong Coal didn't pay because they had a financial difficulty, but the creditors' report suggests there are other aspects to their behaviour as well. Have you read the creditors' report?
No, I haven't.
I recommend you do. Would you be prepared to look into those matters?
Oh, absolutely.
Okay, I'll send them to you. Obviously, making sure that those who do hold mining licences are fit and proper, that's a very important matter for the integrity of the industry. You'd accept that?
Yes.
Are you aware of complaints and allegations of criminality and corruption levelled at KEPCO and their officials in Korea, including the forging of nuclear safety certificates and other matters?
I'm aware there's some allegations around KEPCO.
Okay. And you, of course, KEPCO is the proponent of the Bylong mine here in New South Wales.
Yes.
Are you looking into whether or not there are outstanding probity issues involving the parent company? And if not, why not?
If I could take that precisely on notice, but
Please do.
We have started and commenced an investigation into a number of mining title holders, KEPCO being one.
Yeah, because there was an issue about some photographs they were using.
That's
you were
it.
prosecuting them, but you decided not to prosecute them, but to take an enforceable undertaking. Is that correct?
Absolutely correct.
So they've got a bit of form here in New South Wales already for not necessarily playing by the rules. That's correct.
Well, that's correct, but
Not as an interjection.
any regulatory framework is a framework in this state that's considered to be proportionate. So, and Wollongong Coal is exactly an example of how we've scaled up properly within a regulatory framework and taken prosecution proceedings after having taken other steps to ensure compliance.
Okay. And will you look at those other matters relating to KEPCO's conduct overseas in Korea, and including the issues for which I think the New York Securities Exchange were investigating them?
We absolutely will look at that.
Okay, thank you very much. In relation to Wollongong Coal, do you have a time frame for completion of your investigation?
No, we don't have a time frame because I'm unable to ascertain when the matters within the Indian jurisdiction will be resolved. But what you can be confident about is whilst ever we, as with all title holders, but particularly Wollongong Coal, we are using other parts of the Act to ensure that any non-compliances that are occurring within this jurisdiction are dealt with under other parts of the Act within the framework.
Okay.
And that's evident by the fact that we've taken prosecution proceedings. So it's not like that we've started an investigation and just put it on hold, waiting for India. We're still assessing matters as and when they arise.
Minister, unlike you, I have been out to the Liverpool Plains and I've met with local farmers, traditional owners and other affected members of the community. Will you commit to doing the same before you make a final decision on whether or not to renew the other part of the exploration lease that you say remains under consideration? It's not a trick question.
I apologise for the delay. I'm just trying to get a sense of exactly where it is. Look, I think based on the advice I've received, I'll use my best endeavours to try to do that, but I can't give you an unequivocal guarantee that I'll be able to.
Best endeavours to try. Okay, well, I guess we'll have to make do. I'll come back to
Well,
that.
best endeavours to do that. I'll take tryout just for you, Adam.
Oh, well, I'm overwhelmed, Minister. Thank you. Minister, the Prime Minister says there's more than 1 million households paying more than they need to for electricity. How many households in New South Wales are paying more than they need to?
Well, there's absolutely no doubt that if people shopped around, that they could be paying less.
So it's okay to punish them for being loyal customers, is that what you're saying? For sticking?
That's certainly not what I'm saying.
Well, that's what I
I'm
heard.
saying that shopping around and looking for a market offer, the best market offer, can often save customers as much as 20% on their bills. Sometimes, sometimes even more. I've heard examples.
Yes, but you know as well as I do from the Grattan Institute and other sources that comparing different offers is very, very difficult and time-consuming. You'd appreciate that.
I do appreciate that, and I'm very focused on ways of trying to make it easier, because I'm a firm believer that having a competitive market is the best way of ensuring that we have downward pressure on prices.
Okay. Well, if we assume that of the Prime Minister's nominated 1 million customers who are paying too much, if we assume that about 300,000 of those are in New South Wales, how many of that 300,000 would be receiving one or more of your government energy assistance programs?
Well, I'm happy to discuss how many people are receiving.
Well, I can read the budget
rebates,
papers. I know what
if
you
like,
say in the
but
budget
I
papers.
think you probably have that that information is available.
Okay. Well,
in the
I'll ask a
budget
question
papers.
which you should be
Yeah.
able to answer. What steps have you taken to ensure that the electricity companies are providing the best market offer to customers who are receiving your government's assistance?
Well, we're doing. We've done a number of things, and I'm quite focused on that particular issue right now. But let me just go through some of the things that we've done. First of all, the Energy Retailer Roundtable I've told you about in the House before is relevant, and that emphasised the need for support for vulnerable customers, and there were a number of outcomes in terms of electricity users from that. Secondly, I've written to IPART to request that they advise on the drivers of any price changes to ensure that they represent effective costs in a competitive market. I've also written to IPART to request that they report on retailer strategies to deliver lower prices to hardship customers and retailer processes for managing the rollout of digital meters as well. We've referred to the rebates already, and we've boosted the assistance that's available to vulnerable customers to pay their bills. And finally, the most important thing that we can do is continue to work to ensure that the broken national electricity market that we have is addressed and is reformed, and implementing the recommendations of the Finkel Review remains the best way of ensuring that that happens.
All of you, all of them.
Okay. Minister, the Grattan Institute report on this issue says that governments should actually require electricity companies who are receiving government subsidies to assist vulnerable customers should actually require those companies to ensure that vulnerable customers are on the best possible plan for their pattern of usage. Will you embrace that particular solution, given it's not one of the ones you've
I think
outlined?
their recommendation is a good one.
Will you implement
I've
it?
focused on it, and I'm looking at whether it can be implemented here in New South Wales.
Okay. Because you would agree that it's irrational to provide like a $50 voucher to assist people with their electricity bills when it might actually save them like $1,500 or more if they were on a better offer. You'd accept that's a much
agree
more
with you more.
solution. Okay.
And I'm focused on that issue and looking how it's possible to do that here in New South Wales.
Now, since your government deregulated retail electricity prices here in New South Wales, in the first year, Carbon Market Economics estimates that the retailers increased their fees by 10 to 15%. The year after that, I think retailers put up their prices by 8%, and from 1 July this year, the three big retailers are increasing their prices by up to 20%. So that's 30 to 40% increase in retail electricity prices over 3 years.
I'm going to apologise to the Honourable Member. A text just came in then. I shouldn't have looked at it, but I did, and I lost the thread of this question.
Essentially, retailers have put up their prices 30 to 40% for electricity over the last 3 years. You have not increased the rate of government assistance by that same amount over the last 3 years, have you?
In terms of rebates, the value of the rebates has certainly not gone up by 40%. But I should, in the period that you mentioned, but I should make it clear that there's been an increase, in fact, of around 50% since 2010, 2011.
So a longer period. You said the amount allocated for life support rebate has been increased again. You said that in Parliament on the 21st of June. But the actual rates for the individual amounts have not been increased since 2015, have they? I know your budget allocation overall...
I'd have to check what
Please
my
do.
remarks were in Parliament. I'm happy to take that question and give you a proper answer on those.
Okay, now in the budget papers last year, it said you were going to provide $259 million worth of assistance to help 800,000 households, and this year's budget papers say you're going to spend $257 million, so $2 million less, to support 900,000 households. You've also said that these are protected items in the budget, so no individual claimant would lose money. Can you tell us, for the previous year's budget, what is the estimated percentage of uptake that informed those budget figures? What was the actual percentage of uptake? And what is the assessed percentage of uptake for the figures you provided in this year's budget?
In terms of a number of aspects of the honourable member's question. I've previously responded to him in the House, including a supplementary answer that I gave to the House on that. However, there are a number of aspects to his question
if you take it on
which
notice.
I will have to take it on notice, and I'm sure the honourable member will understand when I'm going to do that. I'm not sure that in fact I'm advised that my officials don't have all of those figures.
No, that's fine. Just going back to galloping electricity prices, recently in the newspaper, BlueScope has stated that their electricity bills are going up by 93% over the next 2 years. You will have read in the Hunter Valley, Miltech are facing 160% increase in their electricity costs, and of course average households are facing up to 20% increases from 1 July this year. And you've talked about your government wanting to put downward pressure, but as you would know, one of the ways to do that is to provide certainty about carbon in the economy. Will your government embrace the Finkel Review's recommended clean energy target?
Well, let's be quite clear. The New South Wales government made it clear in its submission that its policy is that we should have an integration of climate and energy policy.
Yes.
The Finkel Review has come back with a recommendation that it should be via a clean energy target.
Yes.
There are many aspects to such a target that are attractive. It's technology neutral and it provides a market mechanism. But what the state government has said is this, that fixing the national electricity market and even more and as importantly, providing investors with the certainty to invest needs a sensible national plan. Now, what will work best is if the federal government's on board supporting a mechanism. In the case of the of Finkel, it's the recommendation is a clean energy target.
Yeah. But
The recommendations from Finkel came in early June. I said prior to the COAG Energy Council meeting in July, when some of the other state energy ministers were saying that we should proceed with state-based schemes, that the preference of the New South Wales government is that the federal government be part of any scheme.
Sure.
I think it's also consistent with what Finkel recommended when he said that there shouldn't be individual state or schemes of individual states or targets of individual states. My preference is that the federal government is part of whatever mechanism is put in place, and that's why the New South Wales government has said it will make its decision and it will form its view after the federal government announces what it's going to do.
okay.
And we would like them to do that, obviously, as expeditiously as possible.
I think we can all agree that a national scheme, including the federal government, would be a good thing. But of course, as we saw in Canada, sometimes national governments opt out of this. The Labor states, for example, emerging from the COAG roundtable, asked the market operator to design a clean energy target scheme so that they could consider not separate state schemes, but mirror schemes.
Actually, they asked the AEMC, not the market operator.
AMC, stand corrected, to look at not separate state schemes, but obviously the states acting collectively, or at least knowing what a scheme would look like. Would you support the market regulator designing that so that the states and the Commonwealth could look at the detail and more?
Well, I can tell you that the AEMC is doing that work, and so it's having a look at what such a scheme would look like. We haven't asked them to do that, as you said in your question/statement. The Labor states have asked the AEMC to do that work, and it's doing it.
It's doing it?
And when they've done the work, obviously we'll have a look at it with great interest.
Okay. So, just to make it quite clear, you favour something like the clean energy target yourself?
The position of the New South Wales government is that we will wait to see what the federal government says, because we believe that a sensible national plan is in the interests of Australia and most likely to secure a reliable source of power and put downward pressure on prices. We will make a decision after we see what the federal government's response is.